Welcome to another episode of Ask Pallavi A Question. I'm Pallavi Ahluwalia, the principal attorney at Ahluwalia Law Offices, PC. And today we're discussing a sweeping shift that is coming in to how we understand American citizenship, especially for people who are born in the United States to foreign nationals. We are diving into the Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. And joining me today is, as always, thank you, is Sarah Alvey, our front desk manager, who will walk us through the real questions we've been hearing from our clients.
Pallavi, let's start from the top. What exactly is Executive 14160 and why is it causing?
Well, this was signed by President Trump in January of 25, and it reinterprets the 14th Amendment's clause on birthright citizenship. Under this order, children born in the US are no longer automatically considered citizens if their mother was unlawfully present in the US and the father was not a US citizen or a green card holder, or their mother was in the country legally but on a temporary visa, like a student, tourist, or other visa categories that we'll discuss shortly. This is a dramatic departure from the current birthright citizenship doctrine and is currently blocked by a federal injunction, but preparations are being made for its implementation nevertheless.
We've been getting asked a lot, what does unlawfully present actually mean under this order?
Unlawfully present, as is defined by INA 212A9B, refers to an individual who has stayed beyond their authorized period or who entered without admission or parole. But here is where it gets tricky. Not all unauthorized statuses count as unlawfully present. For example, asylum seekers with pending applications or individuals granted parole are not considered unlawfully present under this rule, even if they are technically lacking status. So lawful presence doesn't always equal lawful status, and this confusion can impact children born here to such individuals.
Okay, and what about the term lawful but temporary? What does that include?
Well, that includes people lawfully in the US, but for a finite time. So examples are F1 students, H1B workers, B1, B2 tourists, visa waiver program travelers, DACA recipients, TPS holders, and the list is pretty long. I mean, these are just some samples. It could also include the L1s, the E2s, everyone that's come into the country, right? And are legally present right now, but had children born in the country that would now no longer be considered as US citizens by birth. If a child born to a mother in any of these statuses and a father who's not a US citizen, not a green card holder, the child at this point will not be considered or be granted US citizenship at birth under the Executive Order 14160 if and when it takes effect.
So what happens to these children?
I think at this time, we will have to just see that they will take on citizenship of the country from where their parents belong. So that's the plan for right now.
Isn't this in conflict with the 14th Amendment, and has the court ruled on that?
Yes, it is a conflict and it's already under challenge. A federal court in Barbara versus Trump has issued a preliminary injunction blocking implementation, noting concerns about constitutional overreach. However, the ruling didn't block USCIS from preparing guidance or enforcement mechanisms. So if the Supreme Court lifts the injunction, this EO could take immediate effect. The debate right now hinges on how subject to jurisdiction is interpreted in the 14th Amendment, a clause historically understood to include anyone born on US soil, barring diplomats.
There's also mention of denaturalization and increased civil division activity. What's the connection?
The Trump administration has revived aggressive denaturalization strategies, especially targeting individuals who committed fraud or concealment during naturalization, are linked to terrorism, war crimes, or gang activity, are engaged in financial crimes or falsely billed Medicaid or PPP programs. This isn't about revoking citizenship, it's about signaling enforcement against immigration fraud at every level. Combined with the EO 14160, this administration is drawing a hard line on who qualifies as an American.
What should families do? What should families in temporary status do right now?
Stay calm, stay informed. The EO is not enforceable yet, but USCIS is building an infrastructure in anticipation. If you are a non-immigrant or a temporary protected status and you're pregnant, seek legal counsel to understand your options. We're tracking this closely, and remember, laws may change, but your rights shouldn't be ignored. Thanks, Sarah, so much, and thank you to our viewers. Stay safe, stay smart, and we'll see you in the next episode. Thank you so much.